All right, let's go ahead and get started. So good morning again. My name is Noelle Hicks. I am a shareholder in the Houston office of RMWBH. And today we're going to kind of give what we like to call Collections 101, or like the basics of collections, things that you need to know, kind of an understanding of our internal processes and some updates of recent legislative changes that we think would be really important for you guys in your everyday practice. Let me go ahead and give you our disclaimer. This information is presented today, and it's based on the law that exists as of today, March 22nd. This is used for educational purposes only and not legal advice. If you do need legal advice relating to any of the things that I talk about, make sure you consult either an attorney at our firm or the attorney that represents the association that you're dealing with. Just a couple of housekeeping rules too. I want to make sure that we all keep our microphones on mute. Having your camera on is perfectly fine. I'd love to see your faces, but please keep muted while we are going through the slides today. So let's get started. I want to talk about our goals for today. We are going to discuss assessment collection and the process that goes along with it, compliance with certain statutory regulations. We will evaluate methods of collection, understand certain enforcement techniques and risks, and then we'll talk about some collection policies. I'm also going to be providing you with adjustments to some of these items as we get to them in light of Regulation F. As you know, in our debt collection practices, we have to be mindful of avoiding violations to the FDCPA. More recently, the Consumer Financial Protection Bureau issued its final debt collection rule meant to interpret and kind of advance the goals of the FDCPA, entitled Regulation F. So you'll hear me refer to that throughout the presentation. Regulation F is the largest and most significant supplementation to the FDCPA since it was enacted over 40 years ago. So this new rule has really changed the way creditors and debt collectors do business. Specifically, it alters the way we communicate with our debtors or homeowners in our case, including voicemail messages, email communication, and even text messages in certain circumstances. All of those relating to the collection of debt from consumers. So I'm going to highlight any adjustments that we need to know about pursuant to Regulation F as we proceed. So let's go ahead and dive right into the process. This slide actually reflects the requirements for a 209 notice, which I'm sure all of you are very familiar with. As you know, this is a critical step in the collection process, and the association has to send a letter which contains all of this information that I have here on our slide. Of course, it's okay if the association is sending additional notices, but this one is very important because it's where the association derives its ability to seek reimbursement of attorney fees, and also gives the information that a homeowner needs to know as far as the collection process is concerned. So one of the first items that's required on a final notice or a 209 collection letter is an itemization of the total amount due. So this is the first adjustment I'll mention under Regulation F. We'll talk about the itemization. I just want to make sure I remind everyone to go ahead and mute their microphones as we go through the presentation. So previously our practice was to obtain a copy of an expired 209 letter and an updated account history. We would then update our internal ledger to reflect any increases in interest, additional costs, and any monthly assessment amounts. So now, under Regulation F, we are required to include a validation of debt with our notices, and this validation of debt must contain an itemization, which has to be calculated on an itemization date. You guys don't necessarily have to worry so much about the definitions of these things. These are just internal things that we want to make sure that you know about. So the statute actually provides specific references for the itemization date. The relevant one for our purposes is the last statement date, which is the date of the last periodic statement or written account statement that's provided to homeowners, which would likely be contained in the 209 letter. So this brings up a couple of issues that I want to remind you of. Of course, you want to make sure that the amounts in the 209 letters that you're sending out are accurate, but also this means that when 209 letters expire, there is a continued need for collection efforts. So say, for example, an owner has not responded to this 209 notice within the cure period, then that matter needs to be turned over to the association's attorney for collection as soon as possible. Any amounts that are incurred after the expiration of the 209 letter will be captured in a lawsuit where appropriate, And if an owner pays during the cure period, any fees that incurred after the 209 letter will need to be added to the account and then potentially collected at a later date. So that's just vital information that you need to know about the itemization that should be contained in the 209 letter. But also, in addition to that, of course, the 209 letter needs to be sent by certified mail. And with the bullet points that I'm providing for you, the corresponding section of the Texas Property Code is also included. The period to cure, that is has been changed to 45 days instead of 30. You should also include any options for payment plans. Let the owner know that attorney's fees will be incurred if collection process has to proceed beyond this 209 letter. Give the owner an opportunity for a hearing before the board. If there is going to be some sort of suspension of a common area usage, then that also should be contained in the letter. And then finally, the military notice, letting the homeowner know that if they are members of the military, then they might be entitled to special relief from any debt collection. There are some additional notices that might be sent out, such as lien affidavits or balance due letters or courtesy notices. Those would come up as they are needed, but those are just additional letters that we might send out during our process. So now that you've turned the matter over to our office, right, you've sent out that 209 letter, you've gotten no response from the homeowner, you might be wondering how we manage the file internally. Well, after we set it up, then we send our initial demand letter. So this is what we call the attorney collections workflow. Well, in light of Regulation F, we have had to adjust our practices a little bit. So instead of us sending an initial and a final demand letter, we will only send one demand letter where appropriate. And I'll talk about where it's appropriate in just a second. Under the FDCPA, we are required to provide a homeowner with 35 days to respond. And another adjustment pursuant to Regulation F is also this validation of debt. I mentioned it briefly earlier, but we will also attach a validation of debt to the demand letter. There's a specific form that we have to follow. This validation of debt contains certain information. I won't go through all of it, but just for example, the mini Miranda language, which indicates to an owner that this is an attempt to collect a debt. It should have the firm's name and mailing address, of course, the owner's name and mailing address, the association's name, account number, and the itemization date, so on and so forth. There's also other optional information that can be included, but those things that I just mentioned are some of the very basic information that should be included on this validation of debt. We do have some clients that request that we send or that we file a lien in the real property records. So in that case, we would also send out a lien notice letter advising the homeowner that a lien has been filed and that, that lien would be something that affects the interest on their property or affects title to the property. Also, if the declaration calls for it, we would also send out an inferior lien holder notice letter, which provides 60 days for the lien holder to respond to this collection effort. Finally, during the time that we refer to this as like pre-litigation stage, this is how we refer to it internally, there will also undoubtedly be some communication with owners who are calling in to pay or to dispute the debt or what have you. So Regulation F has also changed the way that we communicate with owners. There are two major methods of communication and a couple of new rules that I want to point out. So generally, our major point of communication with homeowners is going to be phone calls or email communication. So with regards to phone calls, debt collectors now may not call a particular consumer more than 7 times in 7 consecutive days. So that's what we refer to as the 7-7 rule. Secondly, debt collectors may not place a call to a consumer within 7 consecutive days after having had a telephone conference with the person. And that telephone conference has to have some connection to the collection of debt. And then third, debt collectors may only call a consumer between the hours of 8 a.m. and 9 p.m. and may not call them any place or time known to be inconvenient to the owner, such as their place of employment. So these are some updated rules that we have to follow related to Regulation F. We refer to these again as the 7-7 rule. In addition, if we're going to leave a voicemail message, there is a certain script that we would have to follow, which severely limits the information that the debt collector can transmit to the consumer in the voicemail. So yes, we can have conversations with an owner that contacts us, but we cannot make phone calls that are outside of this 7-7 rule. So again, no more than 7 times in 7 consecutive days. Now, with regards to electronic communications, go back for a second, Kyle. In order for the debt collector to use email or text messages when communicating with the consumer, they first have to obtain consent directly from the consumer. In addition, the consumer is given the right to opt out of communications by text or email, so long as they notify the creditor or the debt collector if they wish to have those communications to cease. So if no payment is made or no payment plan is executed, then, and after we've had this whole attorney collection workflow proceed, then we will request authority to proceed with the lawsuit. Now, under Regulation F, since things are a little bit different, since we are going to be sending out just one demand letter, us getting to the lawsuit stage will be a little quicker than it traditionally would have been. So we would be requesting that authority to proceed with the lawsuit sooner than we would have in the past. As an aside, too, for management companies that qualify as debt collectors under the FDCPA, you should be paying particular attention to the changes under Regulation F because they will also affect your business practices. This doesn't apply to all management companies, but just those who qualify as debt collectors. All right, so before we can actually file a lawsuit, we have to get authority from the association to do that. So in order for the association to actually approve a lawsuit, that needs to be done in an open board meeting. Under Section 209.0051 of the Texas Property Code, there are certain things that the board cannot do unless it's done in an open meeting. So one of those things, of course, is initiating collection actions. The board can consider and vote on that during the meeting. And that goes for initiating foreclosure actions, that goes for initiating other enforcement actions. There's a whole list of things that's included there. So in order for this to remain a confidential discussion, it can be considered an executive session. And if it's considered an executive session, of course, the property code requires that anything that's considered an executive session has to be then summarized orally and placed in the meeting minutes. Because what you don't want to do is breach the privacy of individual owners or violate any privilege or so on and so forth. So when you're placing it in the meeting minutes, you could always use some sort of code that is identifiable by the association, but would not identify the homeowner to the rest of the community. So there's a couple of pitfalls that we want to kind of point out to you. And I think, we talk about this a lot, and I've had conversations with a lot of our clients about this, but accepting partial payments is one of the common pitfalls that we come across. The issue with that is that we come up across a defense that's called accord and satisfaction. If we're in court, which I often am, and I have a homeowner say that they, attempted to submit a partial payment and then we didn't accept it, or if they did submit a partial payment and we did accept it, then they can assert this defense of accord and satisfaction. And this actually occurs when the parties agree to discard of an existing obligation in a manner other than in accordance with the terms of their original contract. So in this situation, the terms of the original contract would be payment in full of the assessment amount. And since the declaration is actually the contract that we're talking about, it would also include interest, other costs, and attorney's fees. If a homeowner pays an amount that doesn't add up to the total amount that's owed, then that can be considered an accord of satisfaction, and if the association actually accepts it. So this can become a problem, and I'll talk about that in a second, when you are talking about the application of payments and then what's left on the homeowner's account. It leaves us with very little to actually go to court with or, attempt to collect, because under the property code, we cannot file a lawsuit for simply attorney's fees or, costs and that kind of thing. So we have to be careful of this. Accepting partial payments can be kind of an issue. And part of the reasons why is, again, as I mentioned, it gives the association less leverage in order to collect things, but then there's certain things that you have to consider as far as those partial payments are concerned, right? Do you keep them or do you return them? In my opinion, there's a certain threshold amount that I would return a payment, or, we can look at the timing of the payment. The amount that's left over after the payment may or may not be accepted. And then we would also look at the application of payment statute. So if the payment that's submitted is the exact amount of the assessments, but it leaves all of the attorney's fees, interest, and other things, then you want to consider whether or not you would ever get payment from the homeowner on the amounts that were left over since they've paid off the assessments. It makes it a little bit more difficult when we go to court. Then I have to explain to a judge Yeah, well, the assessments are all paid, but we still have these attorney's fees and so on and so forth, and that just doesn't go over well in a court of law. So, and then sometimes we also get partial payments, a check from a homeowner that has those limiting instructions on it. So if they write on the check that this is for the 2020 assessments only, but they have a delinquency that stems back to 2020, that is an issue, and it's something that we have to take into consideration when we are either accepting or rejecting a partial payment. We have to look at the statutes, we have to look at other situations to determine whether or not they have defaulted on a payment plan. Any statements that an owner writes on their payments can be considered limiting instructions, so these are things that we also need to look out for. So, I talked about previously the priority of payments, and the reason why this is so important is because the property code gives us exactly how payments are supposed to be applied. And it tells us that the payments have to be applied to delinquent assessments first and then current assessments. Then it goes on to attorney's fees, fines, and other amounts owed to the association. So if we accept a payment plan, or excuse me, if we accept a partial payment, then it's obviously going to go directly to delinquent and current assessments first. So that means it leaves us only with those attorney's fees or other costs to file a lawsuit, and we just can't do that. So that's why it's important for us not to accept partial payments. And I'll tell you, this comes up in the context of a homeowner has made a payment directly to the association without our knowledge. We don't find out about it until later when we accept or when we request an account history to update the ledger on our end. And that makes it a little bit more difficult for us because then the owner can say, well, I've made payment and you guys accepted it. So why are we continuing on with the collection process? If a homeowner has defaulted on a payment agreement or what's referred to as an alternative payment schedule in the Texas Property Code, then we are not required to apply payments in the order that's stated here. We can apply them however we want to. So that's something that to be determined at the time that it comes up. So this applies to single family properties, right? There is no priority of payment section of the code for condominiums. So we actually recommend adopting a priority of payment policy for condominiums because it would make it a little bit easier for homeowners and even the association itself to understand how payments should be applied when they're accepting payments of any kind. And honestly, the priority of payments policy can state that payments would be accepted according to whatever schedule you'd like, but it would be best to mirror it similarly to Chapter 209, the section that we have stated here. All right, so how do we make sure that we are accepting payments the right way, or that we have limited the homeowner from taking certain actions directly with the association to make sure that our collection process goes smoothly? Well, we want to make sure that there are adequate controls in place, and this really starts at the association level. So the association and its management company should make sure to flag the account when it's in the legal process. And by flag the account, I mean make sure that the owner does not have access to making payments on their account directly through a website or anything like that, because that's how payments get placed into the account that we don't really know about, and it kind of alters the way that we're able to collect things. If there is a payment that's been accepted from a homeowner directly by the association or management company, make sure that that's communicated to your legal counsel so that we are up to date with all the current information about a certain matter. Make sure all of the employees and board members are trained on these processes so that, if there is payment, that the board and employees all know what to do with it or know how to make the communication to the legal counsel so that everyone's on the same page, and then offer training to board members as to how they can communicate with members, because there are going to be times when a homeowner who's delinquent on their account, maybe they have some sort of relationship with the board member, so they might go directly to that board member and try to plead their case. So the board member should know exactly how to respond to that in that situation if it comes up, and it will. All right, so let's continue our conversation about collections. It's important to point out that relevant debt collection laws apply to both managers and attorneys because they can both be considered debt collectors. Not all the time, but they both can be considered that way. This applies to communities that are governed by Chapter 82 as well as Chapter 209. So what authority do we answer to as managers and attorneys? Well, of course, we are bound by the FDCPA, And then since we're in Texas, the Texas Debt Collection Act. Both prohibit certain methods of debt collection and ensure that the owners, in our case, are treated fairly. And our staff goes through extensive training to make sure they aren't doing anything to violate any specific rules. And like for the purposes of collecting assessments on behalf of the association, a debt collector is any person who regularly attempts to collect debts owed to themselves or others. And then included in this definition are attorneys, obviously, who collect debts on a regular basis. And again, Regulation F is an extension of the Fair Debt Collection Practices Act, which is the reason why we need to make sure we are fully up to date on everything that comes out of that regulation, because it is heavily affecting the way that we're able to collect debt at this time. So in terms of debt collection, courts have actually applied the least sophisticated consumer standard, and this is designed to protect consumers of below average sophistication or intelligence who are especially vulnerable to fraudulent schemes. So one court put it this way. It said, literally, the least sophisticated consumer is not merely below average, he is the very last rung on the sophistication ladder. So in other words, he is the single most unsophisticated consumer who exists, and such a consumer would likely not be able to read a collection notice with care, let alone interpret it in a reasonable fashion. Now, courts do differ on their interpretation of this standard. For example, recently in the Third Circuit, it rejected an idea that the least sophisticated consumer is not capable of reading a plain black and white notice that it gets in the mail. So we can presume a basic level of understanding and willingness to read with care. In other words, debtors should at least be able to use common sense when reading a collection letter, and that's the standard that we should use. So I previously mentioned a couple of times the FDCPA. Of course, it applies to attorneys, and under this statute, a consumer can be awarded up to $1,000 in damages simply because the debt collector willfully violated the law. So now we're getting into consequences of violations of the Debt Collection Act and the liability that can be assigned to an attorney if there's a violation of this act. So the claimant or the owner in this case doesn't need to prove that there was any actual harm in order to receive the statutory damage award. It also provides for payment of a successful plaintiff's attorney's fee. So if they are successful in their claim against a debt collector, then they are able to receive attorney's fees. And then also they can be awarded actual damages under the FDCPA, such as loss of income, other attorney's fees, and even physical and emotional distress. So how can this come about? What are some common violations of the FDCPA? Well, if there was a non-disclosure, if there was a disclosure to a non-owner. So this happens a lot where we have people who claim to be representing homeowners who are not attorneys contact us, and they may be family members, they may be someone to help them speak the language, speak English or Spanish or whatever that the case may be. We cannot disclose any information about a debt to someone who is not the owner. And so in this case, it would be someone who is not listed on the deed as a record title owner of the property. If we failed to provide the required notices or verification of debt, as we've talked about previously, if we attempt to collect amounts that are beyond the statute of limitations, or if we mischaracterize the debt. And then also, these are two new ones that I'll talk about here: violation of the 7-7 rule that I described earlier, and then failing to comply with debt dispute and or opt-out procedures. So debt dispute actually refers to if a consumer refuses to pay a debt or asks a collector to cease further communication. We actually have to cease communication and any attempts to communicate. There are some limited exceptions here, but these are now considered violations of the FDCPA. The last two that I just mentioned come from Regulation F as well. So when we're talking about, debt collection laws, then again, I mentioned that we have to include the Texas Debt Collection Act. And so this one applies to both attorneys and managers. This act defines a debt collector as a person who directly or indirectly engages in debt collection. So the debt collector may not use fraudulent, deceptive, or misleading representation in debt collection efforts. And the reason why is because if there's a violation of the Texas Debt Collection Act, then the person who is attempting to collect the debt can be held liable in certain circumstances. So for a period of 1 year from the date of the violation, violators of this statute can be charged with a misdemeanor punishable by a fine of not less than $100 or more than $500 for each violation. So for each violation, you can be penalized for up to $500. On the civil side, if there is a filing of a violation within 1 year, any person may seek actions for injunctive relief and actual damages. So again, this is a money-related penalty for violation of the Texas Debt Collection Act. What's interesting is that case law has determined that a person is entitled to initiate a cause of action under the Act, regardless of whether or not this person, if the debt is actually the personal debt of the person, because the Act provides for remedies for any person adversely affected by prohibited conduct, not just parties to the consumer transaction. That's something interesting that we just noted. Well, not just noted, that's something that came out in 1996, but it's something that we have to look out for as well. So now, if you don't remember anything else that I've said on the past few slides, then you can really just ask yourself, does this pass the Snip test? And sometimes proceeding with collections just doesn't feel right. Perhaps you or a board member may have information about extenuating circumstances that has contributed to an owner's default. Maybe a board member lives next door to a delinquent owner and knows that they're in the hospital, or maybe this owner normally pays on time and is now a year behind. These things just probably don't feel right. They don't pass that Snip test, right? I've listed a couple of things. And also, if you take a look at the situation and there's no other debt on the property, so, the property taxes are paid up or the mortgage is paid up, this is not necessarily an indicator that something is wrong, but, these things can always be investigated. So think about if the association is spending resources to collect money, but there's an issue that we knew from the beginning that would have prevented the owner from making payments. That can be something that just doesn't reflect well on the association. Another big issue that we've seen over the past couple of years is the impact of the COVID-19 pandemic. Many people have lost their jobs, or they're just getting back on their feet. They might have had their pay reduced or something like that, and they're having to make the decision between paying their assessments or putting food on the table. These are just some things to keep in mind. They're not necessarily definitive things, but just things that we can consider if we know that there's something going on with the homeowner. So ultimately, when we're going through this collection process, the association is threatening foreclosure if the owner fails to pay their assessments on time. So once we go through the entire collection process and there's no response from the homeowner, we are hoping to come out at the other side with a judgment. A money judgment is a court order that awards the association a sum of money. For our purposes, that will be the past due assessment amount, other charges, attorney's fees, whether they are secured and unsecured under the declaration. The declaration already makes payment of those assessments a personal obligation of each owner. However, the money judgment also makes the owner personally liable for the amounts awarded. So that's why we're able to foreclose on the property. If we obtain a judgment, that judgment has to be enforced, and it is enforceable by foreclosure. So under the property code and usually the declaration, you are allowed for enforcement of the judgments by foreclosure. There are 3 different types of foreclosure, and usually the declaration will tell you what type of foreclosure is authorized. So usually for single family communities, we have the authority to proceed with expedited or judicial foreclosure. Expedited foreclosure is a method of getting a file from start to finish, as far as like filing a petition and getting a judgment a little bit more quickly. The problem with expedited foreclosure is that a lot of judges that we encounter don't really understand the process, and they end up making us go through the same procedures that we would for judicial foreclosure, which is why we generally recommend just going through the judicial foreclosure process anyway. Non-judicial foreclosure is generally found in condominium associations, and the language is very specific. Again, our firm doesn't really recommend expedited foreclosures because judges are not very familiar with the processes. It's just easier and just makes more sense for us to go through the judicial foreclosure process. So after foreclosure, the owner has a statutory right of redemption. Chapter 209 actually details these rights. So we are required to send notice to an owner within 30 days of a foreclosure sale. The owner then has 180 days after the date of the notice to redeem the property. If the owner does come forward and redeem the property, then it's responsible for payment of all amounts to the association and any third party that may have purchased the property at the sale. This also includes all of the past due assessments, all costs incurred during the redemption period, interest, post-judgment interest, so on and so forth. Then we also have to send the notice of sale to other lien holders because they also have a statutory right of redemption that begins on the 91st day after the notice of sale. And then there are, in Chapter 82, which of course governs condominium associations, the procedures for the right of redemption are similar, but instead of 180 days, the owner has 90 days from the date of notice to actually redeem the property if they're going to do that. So now we're talking about collection policies. Collection policies are really important, and although they're not required, we highly recommend them because they are going to set forth detailed procedures and practices an association utilizes for collection of delinquent assessments. The policy should actually include the following. So if you move to the next slide. So on the policy, we're going to include the due date of assessments, and keep in mind all of this information is going to come from your declaration or the bylaws. And generally it's going to come from the declaration, but it should include the date of assessments, the due date, notice that cost of collection, attorney's fees, interest, and late fees are going to be collectible against the property as well. It should have a description of the number of letters that may be sent. So some associations will send out a courtesy notice. They may send out an initial notice, and then that final notice needs to always be compliant with Section 209. If there are late charges associated with delinquent assessments and the interest rate, the policy should also include a statement about any payment plans that might be available. So if there is a definite, like, so for example, if the association says we will always accept a 3 to 6 month payment plan, then that can be in there. But then it should also include a statement that says any payment plan that goes beyond 6 months needs to be decided and approved by the association. There should also be a provision addressing the owner's mailing address. So this one is really important. And I'd like to point out that the owners should have the responsibility to keep their mailing address up to date with the association. If they don't, then they'll never receive the notices that they get, that the association may send out. And these would include, notices that let them know when assessments are due and how much they are, delinquent notices, so on and so forth. And so there's a lot of times where we have homeowners contact us and they say, well, I never got any of the notices that you guys sent out. And so in response to that, if there's a collection policy in place that says owners have to make sure to keep their mailing address updated, I can say, well, did you let the association know in writing that your mailing address was going to be different than the property address? And if they didn't, then that's a defense for us, and it's on them. That's also an argument that I can make to judges if we get to that point. Well, Your Honor, the homeowner had the obligation to make sure that their mailing address was up to date, and they didn't. So of course they didn't get the required notices. Keeping in mind, though, that the property code says that the notices that we send are supposed to be sent to the property address. So unless we have some information otherwise, we would have no idea where to send them to. Of course, collection policies may be customized to include much more information, but this is just the basic information that should go in a collection policy. Now, in order for a collection policy to be adopted, there's a certain procedure that the board needs to go through. So, of course, the board will typically have the power to implement rules and policies concerning the collection of assessments. This power is usually found in the bylaws. But so after you, decide that you need a collection policy, you should go to your attorney and have them draft up that policy, one that meets the association's needs. And then the board should review and adopt that policy at a properly noticed meeting where a quorum is present, and it should be approved in open session. Then that information should be included in the meeting minutes. You always want to make sure that you check your governing documents for any other special requirements, but this is the general procedure for adopting a collection policy. All right, so you have an account, an owner hasn't paid in 2 years or so, you've sent the courtesy notices, you've sent your 209 notice, and you've gotten no response. The board should then make a decision to send the account to the attorney, whatever attorney represents them. When the file gets turned over, you want to make sure to include the owner information, so the owner's name and address, a recently expired 209 letter, and the recently expired 209 letter is important now, especially since we have these new adjustments under Regulation F. And then also you want to make sure that that 209 letter has been sent via certified mail. There is a judge in Harris County who has been requiring us to provide a copy of the 209 notice that was sent by the association in evidence that we present to the court, so that she knows that there was actually a letter sent by the association before it was turned over to the attorney. And then also we would want to get a current account history. So that's all the information. So that should be in like a packet that you provide for attorney referral, right? So this makes our setup process more seamless. And then internally, we also obviously have a procedure. Now, I talked about the attorney collections workflow earlier, but there's also the file setup process that we have, right? So what we call POA information sheets. So the attorneys in our office have combed through the governing documents for the associations that we represent and extracted all of the important information that we need for collections. That's kept in a central location that can be easily accessed by assigned users. So that means our, collection paralegals, litigation paralegals, for example. And then that helps us know that if the association requires senior lien holder notice, for example, it's noted on that POA sheet, and we can reference that easily at any time. And when we get a new file, we get it set up in our office. We make sure to run a conflict check, title search, bankruptcy search. We confirm the charges. And then we also make sure that we have the correct owner, that the owner has not passed away, or if there hasn't been some other change that would require a new 209 letter. Keep in mind that those 209 letters, as I mentioned earlier, have to be addressed to the record title owner and sent to the property address unless the owner has specified some other address in writing. This is a prerequisite to us filing a lawsuit. So if you ever get an email or a call from one of our paralegals that requests you to send a new 209 letter, that's the reason why. Then we're going to proceed with our collection process, which I referred to previously as the attorney collections workflow. And that's our process. So essentially, if you guys have turned over the attorney referral information, then we're able to get through this process really quickly. And now, as a result of the adjustments that we've had to make under Regulation F, we are going to be moving our process along a little bit more quickly, getting to the lawsuit stage a little bit more quickly. So it's going to require some quicker communication. We might be getting in touch with you guys a little bit sooner than we normally have to get that process going. So that is what I have for you guys as far as the collections basics are concerned. And if I'm going to check the chat really quickly to see if I have any questions. And it looks like I do. Hold on. The chat, here we go. All right, let's start from the beginning. Oh, I got a lot of questions, you guys. Okay, so the first question is, isn't a certified letter now supposed to be 45 days from the management prior to attorney referral? That's correct, 45 days now. Our letter should be, it's 35 under the FDCPA, but 209 has changed it to 45, so we recommend 45 days. Another question, telephone calls and emails are permitted and appropriate. Yes, they are, but they have to be limited by the rules that I mentioned. So the 7 and 7 rule and the opt-out rule, making sure that if any owner has opted out of email communications, you cease all communication, and make sure you're following those rules under 7 and 7. Can the debt collection job be assigned to a board member or the management association representative? So the debt collection job needs to be handled by the management association representative if there is a contract between the board or the association and the management company, which gives the management company or representative that duty. But of course, if there are associations that are self-managed, then the debt collection job has to be handled by a board member or by the board in general. What kind of efforts do you recommend the association make before proceeding with the lawsuit? So that is totally up to each respective association. And that's another reason why the collection policy is so important, because whatever procedure that you decide to put in place needs to be memorialized in the collection policy so that everyone is on the same page about what that procedure is going to be. So I have some associations who will send, up to 3 notices: a courtesy notice, an initial, and a final. I have some associations that will only send that final notice. You're only required to send one 209 notice by the Texas Property Code. So again, whatever you decide needs to be memorialized in the collection policy, and then that gets filed in the real property records, so it's law as far as your owners are concerned. What percentage of lawsuits actually wind up in getting awarded attorney's fees? So I find that often as the association, we are absorbing the cost, which makes us fearful in this. Okay, so if there any lawsuit that we initiate, at the end of the day, we are going to be including attorney's fees in our collection efforts. So what we would like for it to happen is for an owner to enter into an agreement that also includes the attorney's fees. If we get to the stage where we are trying to obtain a judgment from a court, we are going to include all the attorney's fees that we have incurred up to the date of the judgment in that judgment. And so hopefully we will have a judge that just signs off on, after we prove up the attorney's fees, they sign off on the judgment, which awards all the attorney's fees that we're requesting. We do have some judges, however, who have, judges do have the discretion as far as attorney's fees are concerned. So we do have some judges that will cut our fees or slash the attorney's fees. If that happens, then of course the association is still responsible for those fees, but they cannot be reimbursed from an owner. They can't be sought from the owner at that time. That does not happen a lot, and there are specific judges that we are familiar with that do that, but it's not something that happens a lot. I can't give you an exact percentage, but more often than not, judges are awarding all of our attorney's fees in our judgments. I think that it would probably happen a little bit more if there was some sort of opposition to a judgment or a motion for default or summary judgment, but there's a small percentage of judges that will slash fees. All right, if a board elects to send a courtesy letter prior to sending a 209 letter, should the courtesy letter indicate a due date of 30 days or 45 days? If 30 days is acceptable, should it also include the 209 language, even though the language indicates 45 days? So if you're going to send a courtesy notice, it does not have to be compliant with Chapter 209. But if you want things to be uniform, I would say go ahead and make it so that it's 45 days for everything. That's just my recommendation, so that there's no confusion. You don't want a homeowner to say, well, I got this one letter that said 30 days, and then I got another letter that said 45. So I would just make sure it stays uniform. Okay, so you said a named person has to be communicated with. What if a spouse is not listed? So the person who is the record title owner has to be the person that you talk to. You cannot speak with anything else, and that's actually a violation of the FDCPA. So if it's a spouse, that person can contact us, but we would have to get third-party authorization from the actual record title owner in order to speak with anybody else. Another question, statute of limitations for collection. Is there any attempt? If there is any attempt during the 4 years to collect assessments, would the statute of limitations still apply? Yes, the statute of limitations is based off of the date that the debt actually was incurred. So if it's March 2022 right now, today's the 22nd, anything that was incurred 4 years before that, the statute of limitations runs out today. So let's just say March 22nd of 2018. So anything that was the March 21st of 2018 and before cannot be collected. So it's based on the date that the debt was incurred. The March date would be more applicable for monthly assessment, but so since mostly everyone has annual assessments, we would look at the first of the year or even maybe the 31st of January to look at the deadline. Okay, I have had several boards who see a delinquency and say, well, we should go talk to them, and they never listen. So, that is not a great idea, approaching people that we don't know, even if our communities are small. I never would encourage a board to necessarily go and approach a homeowner that's delinquent that we aren't really familiar with, because, you don't want a random person knocking on your door. But I have had other board members who, had good relationships with community members, or who, knew a community member who went and talked to them. That's another way for them to find out if there's some extenuating circumstances. So I would just kind of look at the entire situation and determine if you think that's a good idea. I think another way to avoid having a homeowner go and speak to, or a board member go and speak to a homeowner directly, is to send them a letter and say that they, hey, we can set up a hearing with the board. And then that way, they can come in a controlled environment and speak with the entire board and let them know what's going on. Okay, let's see. I'm scrolling down to get to a couple more questions. Yeah, all of the responses to that question about going to talk to a homeowner individually, I agree with pretty much all of that. Bobby asked, is this presentation going to be emailed for us to reference? I'm sure that Kyle can make this presentation available to everyone. I know it's being recorded, so it will be on our YouTube page as well. When someone is on a payment plan, can we send them monthly statements stating balance, past due, final notice? If they're on a payment plan, I would not recommend you sending final notices, especially if they're current on their payment plan. You can provide them with balance due if that's something that you do for the rest of the community. But what you don't want to do is confuse a homeowner who's on a payment plan. So if they have a plan that's in place and then there's a different amount that's being sent on a notice or a balance due or anything like that, then I would not recommend that. If there is a owner that's on a payment plan and then they miss a payment, then maybe you can send a notice, a delinquency notice, or a catch-up, default letter or something like that. Is there a separation of the late fees and the amount actually owed when there is a delinquency when paying the association fees? All right, if I'm understanding this question correctly, the answer is yes. So essentially, when we send out letters, we have to provide an itemization. So everything is going to be separated out. The assessments will be separated out, interest, late fees, so on and so forth will be separated out. And then whenever an owner makes a payment, whether they're on a payment plan or not, we have to go back to that payment application policy that we spoke about earlier to apply the payments in the correct manner according to the Texas Property Code. So yes, everything is separated out and things get applied differently according to the payment application policy or according to application of payments in Chapter 209. Would a recent 209 letter, when we are turning over a file, be considered anything less than 3 or 6 months? So now that that we have Regulation F in place, I would say that we need to do it sooner than 3 to 6 months, right? So if the letters that we send out from our office, our demand letters, are supposed to exactly reflect what the last statement that was sent to the owner is, and technically, in most cases, that last statement is going to be the 209 letter from the association, then you would want to try to get your 209 letters and that referral over to us a little bit more quickly, or to whatever attorney that you use more quickly, so that we can make sure that the amount that's on the 209 letter is as close to what we put in our letter, as what's actually due at that time. So I would say 3 to 6 months is a little bit too long. We need to work within like 1 to 3 months at this point. Because even if it's an association that doesn't have monthly assessments, we still have to take into account any interest or any fees, collection fees or administrative fees that are occurring at the time. Is the collection policy usually detailed in the bylaws? It depends. So there are some bylaws that have information about collection policies. They have, payment application policies, that kind of thing. I more often than not see that in the declaration. But what I was talking about earlier is a completely separate policy, a completely separate document from the declaration or bylaws that contains whatever the association's procedures are going to be for collection. And then that, once it's adopted by the association, gets filed in the real property records, and that's how it's memorialized. I don't see the rest of Rosemary's question, so I can't get to that one. Let's see. In the Article 209 letter, are we required to completely itemize the past due balance between assessments, late fees? Right. So in the 209 letter, you want to make sure that you're itemizing the account statement. So if there are, for example, assessments, interest, late fees on the account, then you want to make sure that those are detailed out, itemized line by line, according to whatever year that they became delinquent. So for example, a delinquency that goes back to 2020. For the year 2020, you want to have assessments, interest, late fees on there. 21, assessments, interest, late fees, and so on and so forth. So yes. We have an issue with the builder credit on some delinquent accounts. If we choose not to send these accounts to the attorney until the issue is resolved, is it discriminatory to send other delinquent accounts without this issue to the attorney? No, it's not. But we might need to talk about this one a little bit later. And so I will get in touch with you afterwards to discuss this a little bit more in detail. Allison, doesn't talking to one owner and not another also open up liability? Right. So the question is, doesn't it open up the board for liability to be accused of discrimination if you're talking to one owner and not another? Yes, I think the answer to that is yes. So if you're going to speak to one homeowner, then you probably should speak to them all. But the issue is that you may not have access to all of the homeowners. So I don't think that the association could be accused of discrimination if they are speaking to whomever they have access to. But again, I don't love the idea of going and speaking to individual homeowners about their delinquencies. Does RMWBH send default letters if the homeowner defaults on a payment plan? Yes, we do. I have a couple more minutes here, so let me go through a couple more questions. What do we do if a homeowner is in arrears for a couple years and says they have not received notices because they are not living in the house but leasing them? Would the association be able to collect attorney fees if it turns out that they have not been receiving the notices? So this is part of what we were talking about earlier. If the association has somewhere that the homeowner is required to update their address, their mailing address with the association in writing, then this is not a viable defense from an owner. And actually, the property code says something similar, right? So it basically says that the owner is required to make sure that their address is up to date with the association, because literally, how else would the association know where to send any notices? So this is not necessarily a viable defense from a homeowner, but you would want to look at the entire circumstances just to make sure. All right, if a homeowner is on a payment plan and the new assessment year payment becomes due, can the demand that the current year assessments be paid in full and reject any request for a new payment plan? This is probably going to be something that is on a case-by-case basis, because the property code basically says that the association is required to give a homeowner an opportunity to enter into a payment plan. The only exception to that is if the owner was on a payment plan within the previous 2 years and they defaulted. The answer to this is probably no. Let's see. How would a judge look at that if it was their claim? Granted, a homeowner should know that they have to pay dues annually with or without notice. Right, Miriam. So a lot of times judges are sympathetic to homeowners who come in and say that they didn't get notices or, didn't know that they had to pay their assessments. And so they will hopefully they will ultimately say, well, the law states that you're supposed to pay these assessments. You bought into a community that you knew was deed restricted. You need to go ahead and pay your assessment. A lot of judges will kind of make it so that they don't have to deal with this at all and try to make me and the homeowner work it out if I'm the attorney that's going to court. But more often than not, the judges that understand this type of law that we're dealing with, they will go ahead and, sign our judgments, essentially, make it so the homeowner does have to pay. But I will say that they like to kind of not touch these at all and would prefer for us to work it out amongst ourselves. If a homeowner is with the attorney and walk in to make a payment on their water bill, can we take that payment? So I think the answer to that is yes. But it depends on what the declaration says as far as accepting payments for assessments versus, I'm sure that in this situation, the water bill may be a part of the assessments. If there are other delinquent assessments and they're just coming in to pay the water bill, I don't think that you can not accept it because it's part of the utilities. So we need to take a look at your declaration if you want to contact me after this so that we can talk about that a little bit more. We have 5 minutes left, and I have one more question. Follow-up to response about memorializing collection policies. What's the procedure to compose that? If we have a management company, would that typically already have one composed for the association they represent? I don't know whether or not the management companies will have collection policies on file. What I do know is if an association needs a collection policy, they can go to their attorney and have one drafted. The attorney will review governing documents that are specific to that association and compose a collection policy that reflects whatever procedures that the association wants to follow as far as collection is concerned. And then that goes into a document that later gets reviewed and then adopted by the association. and sits back to us, and then we record it in the real property records. I hope that I have answered everyone's questions. I don't see anything else here. If you guys want to get in touch with me after today, you are more than welcome to do that. I can be reached at nhicks@rmwbh.com. Thank you guys so much for all of those questions. Those were really great. Shows me that you were paying attention to all the information that I gave you today. Again, if you have any other questions, feel free to reach out to me. But that is all I have. Thank you so much for attending today, and you guys can go have lunch now. Thank you all.